What is aggravated driving while intoxicated in New York State? An aggravated DWI charge in New York can raise immediate fears about your license, your record, and what happens next. In New York, aggravated driving while intoxicated generally refers to enhanced DWI offenses under the Vehicle and Traffic Law. One common basis for the charge is operating a motor vehicle with a blood alcohol content of 0.18% or higher. Another serious basis involves driving while intoxicated or drug-impaired with a passenger age 15 or younger in the vehicle. Under New York law, a driver commits aggravated DWI when the BAC is 0.18% or higher while operating a motor vehicle. That higher BAC threshold makes the offense more serious than a standard DWI. For a first offense based on a 0.18% or higher BAC, the charge is usually a misdemeanor. Even so, the penalties are harsher than those for a first standard DWI. A first aggravated DWI can carry fines ranging from $1,000 to $2,500. It can also bring up to 1 year in jail. The minimum license revocation period is at least 1 year instead of 6 months for a first standard DWI. New York law also requires probation or conditional discharge and an ignition interlock device in any vehicle the person owns or operates, subject to the statutory minimum period. Court surcharges may apply as well. Some drivers may be eligible for New York's impaired driver program to seek conditional driving privileges. Aggravated DWI can become a felony in certain situations. A case involving a child passenger may be charged as a Class E felony under Leandra's law. Prior qualifying alcohol-related or drug-related convictions can also elevate a new case to felony level. In general, one prior qualifying conviction within the preceding 10 years can make a new case a Class E felony. A new case can be charged as a Class D felony if the driver has 2 prior qualifying convictions within 10 years, or 3 or more qualifying convictions within 15 years. Serious injury or death can also lead to separate felony charges such as vehicular assault or vehicular manslaughter. A New York DWI or aggravated DWI conviction can also affect an out-of-state driver in 2 ways. New York can revoke that person's privilege to drive in New York. The conviction may also be reported through the National Driver Register's Problem Driver Pointer System, and the driver's home state may take action under its own rules. Jail is legally possible for a first-time DWI or aggravated DWI, especially where there is a child passenger, a serious accident, an injury, an extremely high BAC, or prior DWI history. A defense lawyer may challenge the legality of the traffic stop, the timing and procedure of the chemical test, and the way field sobriety tests were administered. Medical conditions, certain diets, and environmental factors at the test location may also affect breath readings, which is why an attorney will closely examine the facts and available video evidence. At the Inniss Firm, PLLC, clients work directly with attorney Randall F. Inniss, a former New York State trooper whose law firm handles aggravated DWI, standard DWI, and felony alcohol-related offenses. If you are overwhelmed and need guidance, another lawyer at a dedicated law firm can explain how these charges may affect your job, insurance, license, and criminal record. Their office is located at 280 NY 211 Suite 203, Middletown, New York, 10940, United States. You can call 845-533-0265 to speak with someone who understands how stressful this moment can feel.